And then finally, we'll hear from Mr. Jeff Pidot, who's a graduate of Princeton and the University of Pennsylvania Law School. Jeff previously was the chief of the Natural Resources Division at the Maine Attorney General's Office. He serves on a number of governing boards of different environmental and conservation groups, and in 2007 received the Lifetime Achievement Award from the Natural Resources Council. Please welcome our second group of panelists.
Well, I too want to thank Nancy and the Center, the Law School, the University of Utah, and all of you. It's good. There are many conferences on conservation easements around the country, as many of you know. It's good to be part, and all of us are, of a conference that thinks critically and examines critically. And by critically, I do not mean negatively or cynically, but rather with a view to positive change. While Maine is a modest state by many measures, it is a giant in one respect, having more land under conservation easement than any other state. With a strong heritage based on private land ownership, Maine supports over 100 land trusts, holding thousands of conservation easements, covering well over 2 million acres of land. 8 years ago, I prepared a report for the Lincoln Institute of Land Policy in Massachusetts, describing what I believe to be the need for conservation easement legal reform. In response, the Nature Conservancy in Maine, which is where I live and practiced law, assembled a working group of land trusts and agencies, and we began a year's work to fashion reforms of Maine's enabling laws that are based upon the Uniform Conservation Easement Act. And from that work in 2007, the Maine legislature enacted what today stands as the first and the only comprehensive conservation easement reform legislation in the country. If you want to read a history, description, and critique of Maine's reform law, you might take a look at my article for the fall 2011 edition of the Duke Journal of Law and Contemporary Problems, which you can find online. I'll focus here on some highlights of Maine's legal reforms, the overall design of which was to protect the durability of conservation easements while adding no significant burdens on landowners. The reforms deal specifically with these 5 topics. First, universal registration of conservation easements. Second, backup enforcement of easements where the holder has gone out of business or otherwise fails in its enforcement duties. Third, required easement monitoring. Fourth, survival of easements from the risks of extinguishment due to tax foreclosure and fee merger. And fifth, requirements for easement amendment and termination. Let me describe each of these measures one by one. So first, universal conservation easement registration. In the absence of a system for keeping track of conservation easements, inevitably, some will be orphaned or otherwise lost over the indefinite period of time that is the hallmark of conservation easements. Maine's reform law tackles this problem by requiring holder registration with the state of every conservation easement, regardless of when created, whether before or after enactment of the law, and regardless of the type of holder, whether land trust or government agency. Registration is accomplished online for a modest fee and must be updated annually to report on monitoring, assignment, ownership change, amendment, and termination. According to my survey of land trusts for the Duke article I referred to, this registration requirement is well supported by Maine's land trusts. Indeed, the most negative criticism heard was that there is no financial penalty imposed upon those who fail to register and annually update as the law requires. That said, compliance with registration requirements has been remarkably good by all types of holders, with the perhaps inevitable exception of smaller municipalities. The second area of our reforms deals with backup enforcement. Without a system of backup enforcement of conservation easements, when their holders have failed, over time, many easements will inevitably be forfeited. Maine's reform law deals with this problem by enabling backup enforcement of all conservation easements by the state attorney general. Specifically, the AG may undertake direct enforcement when the easement holder goes out of business, becomes bankrupt or insolvent, or fails to take reasonable action to enforce after a 90-day notice. Despite theoretical concerns expressed in other places about the prospect of AG involvement in enforcing private conservation easements, Maine's land trusts have expressed broad support for this approach. Maine's law could be strengthened by granting immediate power to the AG to enforce in emergencies, as well as by designating a default holder to monitor easements where the original holder has disappeared. The third area of our reforms, monitoring. While everyone acknowledges the fact that conservation easement enforceability depends on regular monitoring and detailed property documentation, to my knowledge, Maine is the only state that mandates this across the board. The reform law requires the holder to monitor each easement at least once every 3 years and to permanently keep monitoring reports. While Maine's land trust community supports these monitoring requirements in general, some would like to see the law strengthened by requiring monitoring every year and specific requirements covering baseline documentation consistent with Land Trust Alliance guidelines. Even so, Maine's law at least establishes a legal minimum which can be overseen through our registration system that requires holders to report annually on their monitoring efforts. The fourth area of our reform, merger and tax foreclosure. Conservation easements can be extinguished due to municipal foreclosure if the landowner stops paying its taxes. Simple as that. And while Professor McLaughlin has written compellingly that the common law of merger should not be applied to extinguish a conservation easement when the holder later acquires the fee, some still believe that such an occurrence might jeopardize the easement. Maine's reform law tackles both these risks by assuring survival of conservation easements from extinguishment due to tax foreclosure and fee merger. And fifth, amendment and termination. Nothing about conservation easements has generated more heat than how to deal with their amendment and termination. While Professor McLaughlin has often and convincingly written that these procedures should comport with common law charitable trust principles as the IRS requires for termination of donated easements, Maine's reform law eliminates doubt by providing practical, procedural, and substantive requirements for easement amendment and termination in a fashion not inconsistent with the charitable trust doctrine. In a nutshell, the reform law differentiates between amendments that do not materially detract from the conservation values protected by the underlying easement and those that do materially detract. The former may proceed by agreement of the holder and landowner, with the only requirement being that the holder report the amendment in its next annual registration update. However, in the case of an amendment that would materially detract from the conservation values protected by the easement, including, of course, any termination or easement trade or swap, Maine's reform law requires court approval in an action in which the state attorney general is made a party to represent the public interest. The court must consider the conservation purposes expressed in the easement, the public interest, and other issues that can include the traditional factors in a cypre proceeding under the charitable trust doctrine, as required by the IRS for termination of donated easements. As a further and important requirement of Maine's reforms, when the value of the landowner's fee interest increases due to any amendment or termination, that increase must be paid over to the easement holder to be used for protection of lands consistent as nearly as possible with the underlying easement's conservation purposes. Thus, landowners cannot be enriched by an easement amendment or termination, thereby eliminating pressure to get rid of easement restrictions in order to realize economic benefits. This provision is significantly more protective than the minimum requirements of the Treasury regulations for terminations of donated easements, in that Maine law applies to amendments as well as terminations, applies to all easements rather than just donated ones, requires landowner payment to the holder forthwith rather than only upon a subsequent sale or exchange of the property, and enables recovery of the appreciated value of the easement as of the time of termination, if larger than the typically lower proportionate value at the time of donation, which is the minimum required by the IRS. Maine's land trust community has expressed support for these provisions as well. They particularly like the fact that the system is sufficiently rigorous that it deters landowners from wanting to pursue undermining amendments to their easements. But the land trust community has expressed the idea that they would like the law to include a formal provision for Attorney General sign-off of amendments that do not need court approval. In short, while Maine's legal reforms impose modest administrative and financial burdens on its many land trusts and other holders, those who work with the law have voiced nearly universal approval because it significantly fortifies the durability of conservation easements, of which Maine has so many. So what's missing? You might want to know what significant issues Maine's reform law did not deal with and why. I'd like to deal with just a couple of those. First, public participation. Since the idea remains unpopular among land trusts in Maine, as it is in many states, there is no provision in the reform law that enables public review, comment, oversight, or any other form of public participation in private conservation easement creation. This is due to widespread, but in my mind, overblown fear that any public involvement in private conservation easements will significantly impair their formation. It is important to note that this has not been the experience in Massachusetts, where public hearing and government approval have been mandatory for private conservation easements for more than 40 years. Another area that we left out purposefully, while conservation easements are often praised for their tailor-made adaptability, and I've written before about the need for greater standardization of easement forms, at least for what we think of as their legal boilerplate. Maine's legal reforms did not attempt to deal with this thorny issue, as has been done in Massachusetts, where there is a state conservation easement template. That said, an active group of conservation easement lawyers in Maine have worked up standardized forms to deal with this issue on a voluntary basis. And another area that I've already mentioned where we did not provide something that has come to light as being an area that should be changed is a formal Attorney General sign-off for amendments not requiring court approval. Such a legally authorized sign-off would avoid running the risk that someone in the future, perhaps a prospective property buyer, title examiner, or a different Attorney General, might question a decision not to obtain for what was believed to be an amendment not requiring one. So all of these provisions allow other states in the future looking to reform their statutes an opportunity to make improvements on what Maine has usefully but imperfectly accomplished. Thank you.